Final case set for argument is Noble versus Noble. It's case number 19CA011472. Naomi Noble did not file a brief in this case, so we'll just be hearing arguments on behalf of Wesley Noble. Counsel, you'll have 15 minutes.
Thank you. Good afternoon, and I won't reserve any time for rebuttal then, since I don't have. And I don't know that I'll even go 15 minutes. Good afternoon, Your Honors. My name is Wayne Nickel. I represent the appellant, Wesley Noble. This was a case that lasted several days over in Judge Janik's court, in Lorain County Domestic Relations Court. And I think the main issue that I think is going to cause this court to reverse the decision is my number one argument, which is the idea and the order that my client's Social Security benefits were ordered to be divided by way of a qualified domestic relations order. As I cite in my brief, it's almost black letter law that this cannot be done. Social Security benefits are federal, and the case that I cite, the United States Supreme Court case of Izquierdo, directs this court, or excuse me, not directs this court, but directs that it just simply cannot be done. So I think on those grounds, on that issue alone, I think this court will reverse the decision of the trial court. But going into the other arguments, which were there was a huge discrepancy in the division of the assets. And right off the front, and as I think I point out in my brief, and you'll read in the record, my client, Wesley Noble, and I represent him throughout, is a very simple man. He worked for the steel plant for over 40 years. He collects a pension presently, and at the time of the trial, he was in pay status. He had a 401k, which there was no question that that 401k was liquidated. The 401k was liquidated throughout the marriage, not in violation of any restraining order, as the trial court notes, not in violation of any rule or anything that was nefarious about it. He liquidated it. Now, his wife testified, I believe, she had no knowledge, A, that he even had a 401k, or B, that he liquidated it. That was her testimony, I believe. But the testimony also was that they lived in a house in Oberlin, which was ultimately paid off, and there was no mortgage at the time of the divorce trial. That they owned a property in Sawyerville, Alabama, which was worth $250,000, that there was never any mortgage taken out. That property was built in part due to my client's efforts, his liquidation of the 401k and utilizing of those funds. Now, admittedly, there was scant, if not any, records that my client kept over the course of the years in building that property in Sawyerville. And the trial court almost punished my client for that aspect. I've been doing domestic relations for nearly 15 years. You either have a client who has all the records and is super meticulous about it, or doesn't have any records at all, and you're left with what I was left with in this case, and what Wesley Noble was left with in this case. But what he was left with was no debt, absolutely no debt. A property in Oberlin worth $250,000 by stipulation, or just about, I think it was $225,000. A property in Alabama worth $250,000. So $500,000 of assets, a liquidation of a $225,000 401k, and the trial court says, you didn't keep records for the liquidation of these funds, so we're going to punish you.
Was there a third property?
There was a third property that my client, there was what was called heir land. That was not purchased, but the actual building that he built on this heir land that he resided in Alabama, that was about, I think it was a...
Was that the Winfield property?
Yeah, we called it double wide, I guess, and there was the two storage sheds that he put together and made a dwelling out of. He called it throughout the, you'll see, he called it his man cave.
Was the evidence that he sold the property and did not disclose the proceeds?
He did not, the Winfield property?
Yeah.
I believe the Winfield property so there's two properties in Alabama. One was the $250,000 property, and then the other property was this Winfield property that had the where he resided, which was about, I think it was about $30,000 was the stipulation that what this property was worth.
They stipulated to the value of, not the property, but, or to the cost of the construction of the structure on the air land property? Did they, I'm sorry if I just flipped the two.
No, that's okay. I believe there was a stipulation, if I recall, to the value of that property, not necessarily the cost of constructing it. I think actually it cost him less to construct it, and there was a stipulation that that property is worth about $30,000. I believe it's in the.
Okay, I can look, I just, was confused by the statement, but you cleared it up.
Yep. So, as I point out in my brief, this $225,000, it's not like he had it buried in his backyard. I mean, over the course of several years, and some of the tax returns that were admitted, I mean, there was tax returns that went back, I think, 5 to 7 years, that showed this liquidation. And we all know that when you liquidate a 401k, there are tax consequences to that. So at the highest point, this 401k asset was worth $225,000. Arguably, if you completely ignore any tax consequences of liquidating that account, half of that is $112,000, something along those lines. The court nevertheless said, because you did not keep records, because there was a failure to comply completely with discovery, we're going to award the wife a distributive award to the tune of $180,000 more than what was awarded to my client in terms of the assets. And I think that alone is an abuse of discretion based upon the evidence that was presented in this matter and the fact that there was no evidence of economic misconduct whatsoever.
Well, there was talk about that, wasn't there?
There was allegations that, hey, you liquidated this money, you were working, you were making a good living, you didn't really need to use this money to construct the Alabama property.
I thought there was, I read in the briefs that he withdrew some $90,000 or $91,000 from a credit union account. He didn't tell the wife about it. He received insurance proceeds that he didn't give the wife to repair the chimney, the proceeds for a chimney repair that he kept. That he sold this Winfield property for $55,000, kept all the proceeds. I mean, that's financial misconduct, isn't it?
So, with regard to I don't recall the insurance proceeds, but the $90,000 that was taken from the credit union, I believe the evidence showed that, and I'm not sure the trial court found this, I believe the evidence showed that that was one of the withdrawals that he made from the 401k. It went into the bank account and he withdrew that money.
I'll check that.
And then with regard to the Winfield property, he did not sell the Winfield property was where he was residing at the time of while the divorce was going on, where he built the two sheds together. And
so he did not sell that property?
He did not sell the Winfield property.
What was the status of the Sawyerville property at the time of the divorce?
At the time of the divorce, it was a building that was used sporadically for family events, reunions, that type of thing. It was, both parties resided up here. At the time of the divorce, my client would intermittently go down and stay at his Alabama property, but when the divorce was going on, he was up here. And Winfield is it's not exactly next door to Sawyerville. So any operation of that property, wife was kind of handling, but again, it was sporadic. There was no continuing customers. It was mainly used to be rented out as like a hall for families and things of that nature, which is one of the reasons they bought it. There was some indication that wife at one point wanted to use it for a daycare center, and that's why he built this large property, because her plan was to go down there and maybe open up a daycare center. That never came to fruition, but it was still vacant, for lack of a better term.
So basketball court?
Basketball court in there.
Pre-existing, or was it added by your client?
Added by my client. My client, not with his own hands, but he certainly did participate in building this. He's quite the carpenter. But he engaged the services of the Amish to travel down there on 2 occasions. And again, the testimony was, and the evidence presented was, he paid the Amish cash. So there weren't receipts, but he estimated that he paid them close between the two endeavors to go down there to frame this large building, close to $50,000 is what he testified to. Again, admittedly, there was no document that evidenced this, but you have when you construct a $250,000 building, you put cement in, you do this, you do that, and this building ultimately is worth $250,000, and you don't take a loan, and you don't have a mortgage. Again, I think the nature of being able to do that was consistent with my client liquidating the 401k. With regard to this, the award of spousal support and the division of the pensions, there was a stipulation that there was 2 pensions that my client received, both in pay status. One had a premarital component to it, and the stipulation was that they would utilize the services of Kudrow Group, because us as lawyers aren't able to, most lawyers aren't able to make that calculation. So we obtained the services of Kudrow Group to conduct this analysis, to prepare the Kudrows, which preserve the premarital portion of any pension that my client earned. And again, part of, I believe, one of the Steele pensions that he received was premarital. So the stipulation was that those would be, the marital portions would be divided. And Kudrow consultants would perform that analysis, prepare the Kudrow, and that was done. What the trial court did was ignore the stipulation and said, no, we're gonna divide all the pensions across the board. We're gonna divide them equally. And secondly, we're gonna call it spousal support, and we're gonna retain jurisdiction over those issues based on the length of the marriage and the other factors that the trial court enumerated. The problem with that is, once you divide a property, once you divide a pension through a Kudrow, the court, even though it says it's reserving jurisdiction, it's impossible to reserve jurisdiction to then, if the wife were to remarry, hypothetically, and husband said, all right, I want to come back and revisit the, quote, spousal support that was awarded, you can't do that. It's impossible. It's already been divided by the trial court's order. So not only did it ignore the stipulation and take away my client's premarital portion, but then it rendered an impossibility by saying, well, we're going to reserve jurisdiction. It couldn't happen. You couldn't do that. That was likewise black letter law.
Counsel, I have a question for you.
Certainly.
And in terms of the premarital portion, you're just talking the U.S. Steel pension?
I'm not certain which one it was. I know he had 2,
One of
but
them.
yes.
Okay. If there hadn't been that stipulation, could the trial court still have done what it did?
No, I think you're still saying we're reserving jurisdiction. We're calling it, again, the
I'm
trial
talking
court.
about, let me be.
I'm sorry.
No, my fault. In terms of awarding half of all of the pension, I mean, is there still a prohibition? It still has to be marital property, right?
Certainly.
So stipulation or not, still had to look to what portion occurred at the time of the marriage.
Correct.
I guess you could have stipulated the other way around.
Well, and we have it. I can tell you, to answer your question, sometimes in lieu of spousal support being paid, maybe the agreement would be that it would be split down the middle, so that each would be getting 50-50. But that wasn't the agreement in this case, in fact, the stipulation. But yes, they could have done that, I think, if the parties agreed. But if they didn't agree, I think the court has to determine what's marital, what's not marital, and divide it accordingly. Lastly, do I have time? Sure. Okay. Lastly, I just want to touch on the attorney's fees. Again, the trial court was clear that the failure to comply with the discovery orders, which I've outlined in my brief, there was substantial compliance, in my opinion, but the failure to comply with the discovery orders, and I believe they said the discrepancy in income, or maybe that was the case law that was cited. Yeah, the case law that was cited by the trial court in awarding the attorney's fees cited cases where there was a huge disparity in income. And in this case, notwithstanding my argument that the trial court erred in equally dividing the pensions as I indicated, there was no disparity in incomes here. They basically equalized the incomes of the parties, and also awarded wife $180,000 more of net marital assets. And then on top of that says, you got to pay the whole attorney fee bill of council that was submitted. And council's bill was, I think, $13,000. And if you look at my brief, if they're basing it on the failure to provide discovery or discovery issues, if you look at my brief and the exhibit that was submitted, there's maybe 7 hours of time in that total bill that is dealing with discovery issues. And it takes place in one particular month, I think it was July of 18. But there was depositions, there was subpoenas that were issued, things of that nature, which if the court found attorney's fees appropriate, arguably they could award that much. But to order the full bill of normal litigation that occurred, attending settlement conferences, a trial, we weren't able to reach a resolution, so we had a trial. I don't think you can punish a party for having a trial and not being able to come up with, there was no finding that anyone was being unreasonable. Sometimes we have to have trials in these cases, and in this particular case we did. So again, I think that was just adding insult to injury to say, here's $180,000 more net assets, and by the way, you gotta pay another $13,000 total, the total legal fee bill. So again, I think considering all that likewise was an abuse of discretion on part of the trial court. So based upon all that, if there's not any more questions, I would just simply ask that the court take all my arguments into consideration and reverse the decision of the trial court.
Well, thank you
Thank you
for
very
being
much.
present today and for your argument, excuse me. The court will take this matter under advice and issue a decision. The clerk of courts will mail you a copy of the decision when it is filed, and you can also keep an eye out on the Supreme Court of Ohio's website where the opinions are posted. Thank you.
Okay, great. Thank you, Your Honor. Have a good day.